free. And with that, Ann, I'll hand it over to you.
Okay, thanks, Paul. So, good morning, everyone. Just for the video, for the recording, please do not distribute the presentation or the recording to anyone who is not a current employee of Collins. We all know board members sometimes and other people can misinterpret information or use outdated information. So we just want to be careful. But obviously you could share this with your colleagues. If your associations need legal advice, we'd of course, be happy to assist, whether they are not yet a client or if they are a current client. Just a little introduction for those of you, if there are anyone out there who we have not had the chance to work with or meet. My name is Anna Cunha. I'm an equity partner and based out of our office in Walnut Creek. Our firm specializes in common interest development law. Many of you know we have a general counsel department, and we also, of course, have a construction defect department. So if you have associations that are under 10 years old and need an inspection done, the due diligence inspection, we can do that at no charge. Please give us a call. I'm here today with my partner, Colin McCarthy, and our firm's newest partner, Lance Stewart.
His camera is not working at the moment.
Camera. He's waving and saying hello.
I am waving. You guys can't see it, but I'm right here.
As our special promotion, we extended it from I think it's been the last 2 years. We have special rates for new clients. For the first year, they'll receive our low hourly rate and a free board training, which is a manager favorite. And then for current associations, we of course offer board training. But please let us know if you have associations that don't have general counsel or want to switch to general counsel, to new general counsel. Today we'll be talking briefly. This is a brief version of the new law update, the new laws that were passed this year. We'll have time for questions about these new laws and anything at all. We try to set aside time for that for later, since we haven't seen each other since December. This year, there are not as many new laws that were passed as you'll see, and you're probably familiar, or nothing, you're probably familiar that nothing really has changed much, unlike prior years, where we're all running around trying to revise rules or CC&Rs. But that said, there are a few key changes in a lot of the policies that are required for operation of the association, and I think would be helpful. So we'll be talking about those and also our special pricing for ways to deal with these new laws. So at this time, I'll turn it over to Lance.
Good morning, everybody. Again, this is Lance Stewart, and I apologize. My camera is acting up this morning. I can't seem to get it work properly, but I am here. And we're going to dive into some changes in the law. As Ann noted, the legislature was very sweet to us this term. There wasn't an SB 323, an AB 3182, anything where we've got to change the governing documents overnight. And, I think it shows a lot of foresight on their part that they knew we'd all be running around dealing with water gushing into people's homes in the first few weeks of 2023, and we wouldn't have time to deal with things like election rules. But as Ann said, there are some things to be aware of. The main law that directly affects, or the main bill that directly affects HOAs is Assembly Bill 1410, AB 1410, and that touches on a few different issues. It's a bit of a hodgepodge. It goes into members' ability to discuss HOA issues online, rental restrictions regarding roommates, enforcing the governing documents during a declared state of emergency, and board trainings. And we're going to dig into these issues a little bit more. On the next slide, we've got members' rights to discuss association matters online. Quick background. It wasn't always clear historically whether HOA members have the same sort of free speech, right to peacefully assemble, rights that they do under state or federal law in an HOA context. In 2018, the legislature passed a law clarifying that. Yes, indeed. HOA members have the right to peacefully assemble. They can invite a candidate over to the clubhouse to talk to members about issues. They can host, somebody in political office, and the HOA can't restrict that or charge a bunch of fees for doing so, or make members insure the clubhouse, that sort of thing. For all intents and purposes, members have the same free speech, free assembly rights in the HOA context as they do as relates to a government. This comes up in that same context. The question was, can the HOA prevent members from sort of bad-mouthing the HOA online in sort of community messaging forums, internet postings, things along those lines? And the answer was no, the HOA can't prevent that. If somebody wants to go onto a community messaging board, they want to go onto WhatsApp, Nextdoor, whatever, and talk trash about the board, they're free to do so. The HOA can't stop that. The issue that almost came up, and I think would have made a lot of our heads explode, is at one point the bill said that the HOA might have to host members' content on the HOA's own association media. The HOA's got a website, it's got its own community messaging board. There was a point where the bill said the HOA would be required to allow members to go onto that, host their content, including if they're bad-mouthing the HOA. That part of the bill did not pass. But as with so many things we're going to talk about today, it's a good reminder that if you want to protect the HOA's rights for many of these issues, you're probably going to need some sort of policy in place, particularly if this is an HOA with its own website, with its own community messaging board. You're going to want some clarity about what members are and are not permitted to do, particularly when somebody comes along and says, oh, I want to get on this board and talk about how bad our HOA board is. So we have offered since 2018 a peaceful assembly policy. We can adapt that as needed to address internet and social media postings. And as a general matter, we've got an issue right now where we've got an election challenge because a sitting board member went onto a community messaging board and voiced his views on whom people should vote for in a board election. If you have a policy along these lines, it can help to clarify what is and is not HOA media to stave off challenges along those lines. So we do recommend some policies along those lines. And did you want to type in on that?
Yeah, if I just to go off that, but yes, a lot of these restrictions that the association can pass is for members, what type of things is okay to discuss. But a lot of these policies are, I believe, geared towards boards. We know boards who, it's not right, but they want to limit speech and anything that is critical, any speech critical of them or the association, and they can't do that. And this having a policy in place is a reminder to them of the law so that you don't always have to constantly say, I don't think you can do that. I think you need to contact counsel, because they'll say, no, we don't want to talk to the lawyer. We just want to shut that down. So having a policy in place just avoids that dialogue, because members have rights and boards need to understand that, being on the board doesn't protect them from being criticized. It's like they're celebrities or people in public office. They're out there doing good for their community, but they're also subject to criticism, and they should understand that. And we have special pricing for this year to address this new law. Typically, this policy, we charge $14.50, but for this year, we will be charging $12.50 for this policy, which includes a cover letter for member distribution. All right, go ahead.
Cool. All right, and then on the next slide, we have bans on rental restrictions prohibiting roommates. This is, of course, part of the legislature's ongoing effort to address the housing crisis in our state. I make a lot of fun of them. They're doing what they can to try to figure out how to make there be more housing, and every tool that they come up with isn't perfect. Part of AB 1410 says that you can't prevent members from renting rooms to a roommate if the member is living in their unit. We commonly have in governing documents that we draft provisions saying that you can't rent out individual rooms. If your HOA has provision along those lines in their governing documents, that's probably no longer kosher. You can't have a across the board prohibition on people having roommates, and this specifically addresses when the homeowner lives there. You probably still can have a provision saying that a homeowner who doesn't live in the unit, doesn't live on site, can't rent out individual rooms to a bunch of different people. But like everything else, it's something that needs to be delicately navigated. So if you've got something in your governing documents that addresses the idea of roommates, says you can't rent out portions of a home, chances are that's going to need some fine tuning. And of course, we can help with that either by updating a policy or if need be, amending the governing documents.
Yeah. So yes, it's not, those type of restrictions are no longer enforceable, but I think the easiest and most practical way to address that so that there's no confusion is by including it in a rental policy. And in that rental policy, you can also include other requirements like, the process for applying to the board, providing information about tenants to the association, charging, some associations charge a fee for rentals. Those are the type of things, if not inconsistent with your governing documents, you can do it by policy. And so we offer special pricing for that, a rental policy for $12.50, which includes a cover letter. It's normally $14.50. And this is a reminder too for AB 3182. Remember the law from last year. I think Lance will actually be talking about it later, but there's also compliance packages that we offer for your associations who have not yet looked into that or have gotten into amending their CC&Rs and removing the prohibited restrictions, which they were supposed to do last July, but it's okay if they haven't yet. Yeah, there's still a few we're working on.
Absolutely, and of course we can help out with that. The next issue that the legislature tried to address here is a little bit of, thanks very much, guys. You might be a little slow on the draw there. Sometimes watching the legislature respond to things is like watching somebody push molasses up a sandy hill. We all recall that particularly in the early days of COVID, there would be times when boards would decide it doesn't make sense to enforce the governing documents given everything that's going on because of the nature of the state of emergency. Somebody's got an inoperable vehicle sitting in their driveway. What are they supposed to do about that right now? They can't really interact with people. People aren't, completing architectural modifications to their home because the contractor won't come out to the site. How are we going to force the governing documents against them? What are they supposed to do? Boards made sort of reasoned determinations not to always enforce governing documents to the absolute letter because of the situation we were dealing with. This part of the law is intended to address that sort of situation if it comes up again. If there's a situation where, for any state of emergency, whether it's COVID, some other pandemic, God forbid, drought, torrential rainfall, something that prevents somebody from complying with the governing documents, the HOA actually can't enforce the governing documents as relates to that person. Now, the language that's used here is that the nature of the emergency makes it unsafe or impossible for the member to comply. That's a little vague and ambiguous, a little difficult to navigate. I think for practical purposes, if you have a situation where it seems to you in the world right now, it doesn't make sense for this person to comply, the board's sort of digging their heels in on the issue, get us involved, get the governing get the general counsel involved to provide some guidance on that particular issue. This does not have anything to do with people being behind on their assessments. It doesn't change that. That stays as it is. And as Anne's going to talk a bit more about, you might also want to consider updating the fine and enforcement policies to envision this particular scenario, keep your boards out of trouble.
Yeah, that's what we envision, putting in one or two provisions that talk about this so that boards are aware they can't enforce certain restrictions during a state of emergency. But this is also a reminder because we are still seeing some associations who don't have a fine schedule or fine and enforcement policy. So if you run into that issue for any of your associations, please reach out to us. We can do a fine and enforcement policy addressing this new legislation, but also to make it consistent with their governing documents. And our special pricing for that is $9.50, including a cover letter. And as a reminder, associations are required to include that fine and enforcement policy in their disclosures, the annual disclosures. A lot of times it's some generic language that you probably have in your templates, but it may or may not match the association's governing documents. So keep that in mind when you are working on hearing notices and working on fines for associations to make sure they actually have a fine and enforcement policy.
Yeah, I'm always surprised when communities come to us and they've got an enforcement issue and they don't have a fine policy in place. And we can call the guy to a hearing. There's not much we can do with him once he gets there. So yeah, make sure all your communities have a fine policy in place. Okay, board education and trainings. You heard Ann talk earlier about something we really want all of our clients to have. We offer it on a complimentary basis to new clients, and we really want all of our clients to be doing it at least biannually, if not more, and that is the board legal education training. It's a 1-hour presentation that we provide that goes through the nuts and bolts of how you're supposed to conduct the HOA's business. We commonly say to boards, they're volunteers in their spare time operating what is basically a multi-million-dollar corporation, and they get no real practical guidance for doing that except what you guys provide. And this training we provide is meant to get into the nuts and bolts of what is a fiduciary duty, what is the business judgment rule, what can the board do, what do the membership need to do, how does management factor into this? We want our boards to have that grounding and how they're supposed to function to make sure everything's being handled properly and to keep themselves out of trouble. The state legislature this past term said, in essence, we think that's a really great idea. We think there should be board trainings for all boards before they can serve on the board. We're just not sure how to do it. At one point, the bill required that all board members take some sort of legal training before they can, or some sort of training before they can serve on the board. The problem that everyone ran into is how do you decide what that training is? Is it going to be Angus and Terry's board training as presented by Ann Acuna and Lance Stewart and Colin McCarthy, the best in the land? Is it going to be somebody else's? How do we decide the content of that? And so what we end up with is basically a statement of policy that isn't actually in any law. It's just in the bill itself and says, we think board trainings are a good idea. What's the point for you guys? I said it up top. If we're not the general counsel, get us involved. We'll provide a complimentary board training, and we want all of our clients, all your communities to have this 1-hour presentation really to make sure they're functioning properly and keep themselves out of trouble.
For current clients, like Lance said, every time there's new board members, it's a good idea to have training, and even for current board members, because you know how they hear one thing and then it's out the other ear. Every couple of years is a good idea, a good reminder, fiduciary obligations, duty of confidentiality, just the basic things that may not come naturally to a lot of board members, even those that have been on the board for a long time. So many of you have done board trainings with us. We offer the standard board training to current clients for $450, and many times we do a special. We do a little special. If the association is dealing with certain issues, like for example, a board of ours wanted basic board training, but also training on how to review the financials. Things like that, we can also custom tailor these presentations for your boards. So let us know, please reach out. And if you have new association, new general counsel clients, those are, they get the free board training. Colin?
Okay, everybody, hello. Colin McCarthy again here talking about everyone's favorite subject, ADUs and JADUs. As Lance has noted, the California legislature has solved the housing crisis with the enactment of this law. And now it's been complemented. In all seriousness, this is a further evidence of the legislature's attempt to ease the housing crisis. As I had probably told you guys before, there's been like from 2017 until now, every year there's another piece of legislation that just kind of makes it easier to build ADUs. And this is just another feather in that cap. It does the things that you see up there on the screen. Mainly, it's getting rid of some more local agency attempts to kind of block these things. Local agencies can no longer deny an ADU permit for like non-conforming zoning conditions, or actually even building code violations, as long as those are quote unquote not unsafe. That takeaway for that is they're trying to make it harder for local agencies to deny these things, put in objective criteria. As this legislation was set up to have just like certain minimum requirements for the ADU, and if they meet them, the agency is supposed to do a ministerial approval of it. And it probably came through that there was some pushback in these areas, and so they've come down and said you can't deny it on those basis for the non-conforming zoning or the UBC violations. The other things, like if you were going to demo your garage to put an ADU in, there are no notice requirements for that anymore. If there were any, and the local agency can't require those notice provisions. The size of these ADUs have been increased. The new limit, if you're within a half mile of a public transit and you are adding to an existing building, is 25 feet. You could have a 25-foot ADU if it is attached to an existing residential structure. If it's detached, like the one in my neighbor's backyard, it can be up to 18 feet. Small aside, in these heavy rains, I was not immune from the flood works or what have you, and my avocado tree fell. Unfortunately, it did not fall on my neighbor's ADU. So, yeah. But
Colin is your guy for ADUs, folks.
Yes.
Colin is your guy.
So we do recommend that you have a policy in place to navigate these things. Now, you can, as a separate community interest development, you can do a little bit more than some of the regular folks in order to avoid the impact of these things. You can have aesthetic requirements. You can require the process and the application to be done in a certain manner. And you can also require that maintenance covenants be recorded and set forth specific requirements for these. Anybody who wants to build an ADU, good to see you, Lance, on your development. So you want to take control of it as best you can. If you can avoid things that are going to lead to later problems like nuisance provisions and things like that, if neighbors are too close to one another or windows are in the wrong place, you might be able to tweak it a little bit with a policy. So we recommend that if you don't have one already and you anticipate this is going to be an issue, that you get a policy in place before somebody builds an ADU.
Yeah. So this new law, if you didn't quite catch that, it did not directly impact how boards treat ADUs, at least from prior law changes. If you'll recall, a few years ago, the law changed, and associations cannot prohibit ADUs and JADUs. That's why you are probably all familiar with this, that they can impose reasonable restrictions. So that's still the same, and that's why we recommend a policy. But because, as you can see, that new law is making it easier for homeowners to get an ADU or JADU to their property. There are a lot of companies out there just sprouting from the ground that are just do ADUs. And so they are heavily marketing to homeowners. And you may notice in your communities more applications in the last year. We anticipate there will be more in this year and the future years. Because it's easier to get an ADU. And I know some municipalities also have pre-approved plans. Again, cities are making it easier for these ADUs to get constructed. So we anticipate there will be more applications, and we have been actually dealing with a lot of communities that want to deal with these applications and requests, but don't have a policy in place. So they need a lot of handholding and guidance on what restrictions they can impose. So it's good to have a policy even before you get your those types of applications in. Special pricing this year for our ADU and JADU policy is $12.50. And then it's usually $14.50, which is, I think, still worth it.
All right. So another attempt to ease the housing crisis is to allow the easier building of rooms, room additions to existing residential structures. This legislation prohibits local agencies from requiring a public hearing related to room applications. You can add up to 2 without that public hearing. It isn't impact any public hearings that may or may not be required for ADUs and JADUs. It's my recollection that there aren't really that many, and I don't think that there are any required for the ADUs. Again, it's supposed to be a ministerial approval of the applications. So again, this idea here is it's going to reduce the obstacles for people to build them, and you can anticipate that people may take advantage of this law, and probably we would address this, if it comes up, and you don't have an ADU policy. I don't know, Ann, are we addressing this in our ADU policy, or are we?
That's the room additions. No, unless it's an AD. The room happens to be a JADU or ADU. But this will come up as an architectural application.
Right.
And that's how you'll see it. So if there are complex, weird issues that the board needs assistance with regard to architectural applications, we can step in and help.
Yeah, and then there's some CC&Rs have provisions that don't allow major improvements and things like that. There would be an issue as to whether or not this provision overrides that, and you'd want to consult counsel in that context. All right. This is there's a question there by Nicole about the parking restrictions and whether or not they have impacts on parking. There are, generally speaking, the ADU laws do not require replacement of parking if you're within a half mile of public transportation. So if you're taking away a parking spot, like by adding a garage or something like that, and you're within a half mile of a bus stop or the light rail or a train station, then you cannot impose a parking requirement on the application. If you're further than that, there is an argument that you can impose it. And I actually heard a story about an association denying somebody an ADU application because they were not able to replace the parking. And they relied on that. But that is, you would never do that without consulting with counsel and taking a real hard look at distances, the statute, your CC&Rs, and the application itself. But generally speaking, and inconsistent with the theme of let's make these things as widespread as we can, parking is a secondary and ancillary concern. The primary concern is building the housing. So there are a couple of provisions that may require it, but for the most part, you're not going to be able to rely on parking provisions to deny applications. All right. Did that answer your question? Okay, great. Cool. It popped up right as I asked the question. This isn't really a change. It's just a study commission has been formed for building code standards regarding electric vehicle charging stations. And this commission is put together to develop a plan to see what kind of standards we can require for EBCS stations in multifamily dwellings. The idea being is that they want to set uniform electrical standards so that you don't have to have disputes over, well, can I just plug it into my outlet, or does it need to be a certain, low pole or level 2 higher electrical standard? So they're looking at those kind of things. I had a situation where a gentleman wanted to park his Tesla into the landscaper's outlet that was common area, and it was, shutting down the electricity when he plugged his Tesla into it. So, and it was a common area thing, and like, how are you going to charge him for that, and things like that. So we would encourage you guys to, if you don't have charging stations plans in place, you should do it, because there are specific statutes that govern it that are already in effect. And, Governor Newsom wants us all driving in, maybe not Teslas now, but electric vehicles certainly by 2035. So this is coming to your association, and it's coming soon. So you'll want to be prepared. You'll want to have a policy in place that says, that complies with the law, and says that you must allow them to build it in their exclusive use parking area or their designated parking space. They have to pay for it. They have to insure it. They have to, but you have to allow them. And if there's no space there, you might have to set aside some space for it in the common area to do it. So it's coming. We encourage a policy, and I'm sure Ann will have a little bit of something to say about this.
Yeah, so similar deal, special pricing this year for this policy is $12.50. But just overall, as you can see, the theme with ADUs, JADUs, the electric vehicle charging station. I also wanted to bring up solar because they're kind of in the same basket of things that our state, the laws are promoting, and so it's impacting our associations directly in that there is a demand for these things. And when you don't have a policy in place, there's a lot of questions of what the board can and can't do. And there's a lot of laws of what they can and can't do. So it's good to have a policy in place. And if an association is lenient and does allow it, we'd still recommend for solar, for electric vehicle charging stations, an ADU, or for certain types of structures in an owner's property, to do a maintenance, to record a maintenance covenant, so that restrictions and agreements between the owner and the association is recorded against the property, and future owners can be bound by that agreement. So that's important. If for your associations that already have policies, or for your associations and boards that are just allowing it anyway. They should still have a maintenance covenant recorded to protect the association.
Right. Yeah, and you can throw into that basket with solar and electric vehicle charging stations and ADUs, drought-resistant landscaping. Another area where what the HOA can and can't regulate is pretty tightly constrained. And that brings us to watering restrictions. Despite everything we've seen in the past couple of weeks, my understanding is the drought is not over. I'm by no means an expert. That's just from reading the news. Some quick background and context for this one. In 2015, the state legislature passed a law saying HOAs can't prevent homeowners from installing drought-resistant landscaping on their property. You can't do it. Low water-using plants, artificial turf. You can't enforce governing documents provisions that prohibit those things. If there's a drought-related state of emergency, as I believe we still have, you can't fine people for failing to water their lawns. And if somebody installs drought-resistant landscaping in response to a drought state of emergency, you can't force them to remove it when the emergency's over. That's been a law for several years now. And it's like everything else we're talking about. There's a very fine line between what the HOA can and cannot regulate. And if you want to walk that line, if these are issues near and dear to your boards, you really need a policy in place to help them thread that needle. In that same context, January of last year, the State Water Resources Control Board adopted an emergency regulation. They then readopted it at the end of last year, and it's in effect for the coming year, constraining the use of potable water for irrigation, including by HOAs, and specifically regarding incidental runoff. That is, we've got irrigation running and it's hitting more things than it's actually intended to hit. It's going beyond what it's aimed at. Overspray that flows from where the water is supposed to go onto adjacent property, non-irrigated areas, walkways, etc. The regulation also limited using water to hose off sidewalks, hose off structures, hose off parking lots. Limited using it for decorative fountains unless it's being recirculated, and limited using potable water for irrigating turf and ornamental landscapes immediately after rainfall. In other words, be very, very careful with how HOAs are irrigating the property because the board's paying close attention. That same regulation also repeated what I just got through talking about that's already in the civil code regarding HOAs policing drought-resistant landscaping. If the HOA runs afoul of those things, enforces things it's not supposed to enforce, it could be facing a $500 fine per day the violation occurs. And it actually goes so far as to say if the violation is an improper disciplinary proceeding, then each day the proceeding remains pending constitutes a separate violation. So if you're talking about HOAs fining people for not watering their lawns when they're not supposed to do that, the violation is each day of that process. So we've got 10 days for the hearing notice, 15 days for the notice of discipline, $25 at $500 a day. That's a possible $12,500 fine just for the board trying to improperly enforce the governing documents related to droughts. So pay close attention to these issues. In June, the board adopted a further emergency regulation that basically required HOAs to stop irrigating non-functional turf. What is non-functional turf? Well, it's solely ornamental and not regularly used for recreation or community events. What do we do with that? What the State Water Resources Control Board has said in so many words in a letter that was intended for HOAs is that basically boards need to make a determination about what landscaping within the HOA's control is non-functional and what is functional, what is actually being used for soccer games and snowball fights and whatever else, and what's not really being used, and document that determination. HOAs must, and I'm reading from the letter now, HOAs must determine whether turf is functional or not when implementing landscape irrigation. Our expectation is that each HOA notify residents about the drought and allowable conservation actions, along with the HOA's determination about which HOA-controlled turf will be classified as non-functional and the basis for that decision. We're talking about a possible policy, again. We're talking about a possible letter to members. We're talking about basically a judgment call to be made by the board, and we may even be talking about expert consultation. That's what needs to happen here. It raises a lot of related questions. What about PUDs where the HOA is responsible for landscaping on the homeowner's lots? I think there's a decent argument on the face of the regulation and the cover letter that it's not meant to encompass that, but there's also language that suggests it does. It's ambiguous, and it's an open question that each HOA is going to have to determine individually in consultation with our office or the general counsel. And here again, if the HOA runs afoul of these things, you're looking at a $500 per day fine for that violation. So please, 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 if you've got HOAs where the board's really fixated on folks watering their lawn, and you've got big irrigation issues for the HOA, work with us, work with the general counsel on getting an appropriate policy in place to navigate these issues. And anything to add to that?
No, we anticipate people will probably pay more attention to this in the warmer months when people are watering lawns. I know right now everyone's just dealing with not getting leaks into their homes. But yeah, pay close attention to this. If you weren't dealing with it last year in the spring, summer, fall, this will be something to pay attention to in the coming months.
Absolutely. The last one I would file under, if the board sort of does something procedurally wrong, this might help. We can consider it another arrow in our quiver. Ratification of certain non-compliant corporate actions. We talk a lot sort of informally about the idea of boards coming into a meeting and ratifying a decision that maybe was unclear or wasn't quite handled properly. There's not really been anything in the law up to this point that specifically envisioned boards doing that. And now there's a portion of the Corporations Code that allows the board to ratify decisions via board resolution or membership vote, if that applies, of actions that were otherwise lawful but didn't comply with general corporations law or the governing documents or possibly some agreements. What we do with this is a little unclear at the moment. Our colleague Russ Higgins has had some success with applying this to situations. It is not in our read, a get out of jail free card for violations of the Open Meeting Act. Something happens that runs afoul of the Open Meeting Act, you're not excused from the Davis-Sterling Act, that still applies. But if you've got situations where you come to realize, or the board comes to realize, that an action that was taken maybe wasn't procedurally kosher, this is something we can help put together that might give the board a little bit more insulation if somebody were to challenge that decision. Yeah, so consult with us, consult with the general counsel on issues that come to your attention, or if you have a question about whether the board did something properly, and we'll figure out if this is something we can use to help the board out.
I think, Colin, you were going to cover some.
Okay, everybody knows that if you haven't done it by now, your association needs to do it. No excuses. You're in violation. 10%. If you guys can only rent 10% of your units on your in your condo complex, you're in violation of this law. So you have to amend your documents. You guys know this. So if there are associations out there that haven't done it, do it right away, because you could be construed as intentionally, ignoring the law. And then there are some penalties in there for associations that are not in compliance with this law. And all it takes is one of your members to decide that you aren't doing it right, and you're in trouble. So if you haven't already done your rental laws, let's increase the supply of housing in the state of California by amending and allowing more units to rent. Okay.
And as a reminder, you guys have heard this before. When this law changed a couple years ago with this new law, it's not just a matter of having these prohibited rental restrictions not be enforceable.
Right.
The law actually says you need to amend your CC&Rs to remove it. But the good news is, we offer two packages. One is just a compliance only package for $800. And it's a CC&R amendment and a board resolution, and the cover letters for those, they can amend the CC&Rs without a membership vote. If it's just removing that provision, that's in violation of the law. Some associations want to include other rental restrictions, and this is their chance to do it. They do need a membership vote for restrictions that are discretionary, and we have a package for that, $1,500, which includes the CC&R amendment, the ballot, the cover letters, and all of that. So we can provide you additional information for your associations that just want to adopt rental restrictions, put in a rental cap now, or those that need to comply with AB 3182.
Okay, and then the other one that people know about but is now fast looming is the 2025 deadline for SB 326 inspections. So everybody's known about this for a while, and hopefully you've been taking your good faith efforts to get this done. But if you haven't, you should line it up now and get it done, because you're getting your contractor is going to be a challenge, especially with all these, it just gets from bad to worse with the flood conditions and things like that. Getting the right engineer out there to analyze your elevated exterior elements is going to be a challenge. And if you're in a condo complex, you are required to do this. And again, there are provisions in there that will penalize you if you don't do it. So you need to consult with legal counsel to see if you need to have this done at your project. And if you need assistance, it's expensive. Unfortunately, everything that the legislature is making us do, it costs money. You have to pay that engineer to come out there, and if you don't have the reserves for it, then you might need to do assessments, and we can walk you through the process. But you don't get to not do it because you don't have enough money. There's nothing in the law that says that. So unfortunately, you're going to have to comply.
Yeah,
and just sorry, go ahead, Ann.
Oh, I just want to commend Collins. I know you have a team that's dealing with this for your associations with balconies and exterior elevated elements. You guys have been reaching out to us, asking the right questions about components that need to be dealt with, especially for townhome communities. So a lot of those just need a letter from council to confirm that they don't need to do anything with certain components. And then, of course, what Colin was mentioning, assistance with with special assessments and funding these projects, that's definitely something that legal should be involved with. We are always happy to assist. Please reach out with any questions or requests for proposals. Lance?
Yeah, and it's great that you guys are engaging in those efforts. That's wonderful. Because we've been hearing a lot that HOAs are running into trouble where the architect or the engineer isn't sure what to inspect, and so ends up saying, I'm gonna charge X and Y and Z to inspect everything to protect myself from liability. So that opinion letter that we can provide can be a very useful tool if there's any ambiguity about, the architect saying, I want to inspect everything. The whole point of our opinion letter is to navigate, what does the law say? What do your governing documents say in terms of HOA maintenance components? What are the actual things in your community that need to be inspected in order to comply with this law? You give that to the architect and he focuses on what needs to be addressed.
He or she.
Yeah, thank you. I heard myself say that. That was ridiculous.
He or she or they.
Strike that from the record. I didn't use any pronoun at all.
Too late. It was recorded.
Yep. Oh, hey, Paul, can we burn this one?
Sorry. So that's that we have case law too. We in the interest of time and to give time for questions, we're not covering. None of them are big cases that I think that associations need to deal with, but we are here to answer any questions you may have, either about the new laws, the semi-new laws, or just any other legal issue you might be dealing with. Christine.
What happens when we inspect early? Will we have to re-inspect in 2025, or will it make out our re-inspection date early? No, it's every 9 years going forward.
You should get a gold star for doing it early.
Yep.
But yeah, it is 9 years from the inspection. So, but for your associations, you're like, no, we want to wait till the last minute so that the next inspection is way later. We don't recommend it because number one, the vendor, there's a lot of vendors who their availability will be impacted with all the last minute people. So it's not good to wait. Prices tend to go up, are going up. So I don't think it's an advantage to wait until the very last minute just so that they can push out their next inspection.
And Christine, if your question is, well, we did an inspection already, do we have to do it again before 2025? I'd say no, so long as it actually did the things that SB 326 is focused on. We've got some HOAs where they did a similar inspection in years past that doesn't really quite meet the bill. So you want to work with council and make sure whatever was done lines up with SB 326. But otherwise, you're fine. Good job. Other questions, comments, concerns?
Yeah, everyone doing okay with leaks and water intrusion these last few weeks? I think we had our Colin and I presented on that issue a few months ago, late last year. So I hope that came in handy for you.
Must have. They have no questions, so it must have been really good.
Other than that, we put everybody to sleep.
Well, yeah, if there's nothing else, you all have our contact information. Please feel free to reach out to any one of us. Also, Ivy Vu, who many of you know, whether it's board training, proposals, policies, legal assistance. Please keep us in mind. We really appreciate it. And we love working with all of you. And we hope to work with more of you this year. Anything else?
Thanks very much,
All right,
everyone.
thank you so much.
Thanks, everybody.
Thanks, everybody. Take care.
Thanks, Paul. Drive safe, Paul.
Bye, Colin. Bye, Lance.
Bye.
Bye.
Bye, Christian.